Good morning, ladies and gentlemen. It is my privilege, and I regard it as a great honor, to have been invited as a speaker for this session. May I take this opportunity to express my sincere gratitude and appreciation to the kind invitation and all the courtesies extended to me. South Asia, no doubt, has the much needed potential to compete with market leaders of the developed countries. However, it is to be accepted that the South Asian region is currently suffering from poor business conditions, which has tremendously affected its investment climate. Standing on that platform, considering the theme of this year's convention, and taking serious note of the participants present at the convention, I am of the firm view that this is an opportune moment to share my thoughts on the role of the justice system in its contribution to support business and to encourage economic growth in South Asia. Any business enterprise which contemplates attracting foreign investments could face multitudes of problems. This phenomenon is neither recent nor unusual. If you consider the business climate for the past several decades worldwide, it could be seen that the majority of the countries had been having various regulations or restrictive conditions regarding business. If our attention is focused to the developing countries, it could be clearly seen that there are administrative, constitutional, and statutory regulations over investments based on various reasons, including economic necessities. Notwithstanding these, there could be several other restrictions on investments in developing countries that could range from limitations or prohibitions in terms of constitutional provisions, investment laws, or industrial policies. One must not also forget the difficulties a foreign investor would have to face when dealing with currency regulations, foreign exchange control laws, export and import regulations, and tax provisions. A foreign investor would have to largely rely on local labor, and this would automatically make him follow the local labor regulations regarding his labor disputes. For a developing country, an essential feature in its development would be to see that the country has a rapid economic growth. There cannot be any kind of growth without investments, and economic growth especially require many types of investments, which would include human capital, physical capital, time, as well as effort. It must also be kept in mind that investments would only take place if investors are confident that they could reap a profit through their investment. If there are too many obstacles or restrictions over investments, those would act as drawbacks in attracting investors to a country. On the other hand, as we could see in most developed countries, when there are constitutional guarantees and powerful courts that would act as major inducements, since those would reduce the dangers of investments, such as sudden and unjustifiable expropriations without reasonable compensation. The Fifth Amendment of the United States Constitution, which provides that private property shall not be taken for a public use without just compensation, is a fine example. This indicates the importance of having a strong judiciary in attracting investors, as legal protection over property rights through constitutional and statutory guarantees would encourage large amounts of investments. It is interesting to note how attention was drawn to the need for reformation of the judiciary in order to salvage the investments made in a country. To cite one example, on 26 January 2016, the Balkan Insight carried a news item captioning that the investors urged the Bulgarian government to reform its judiciary. In an open letter to state institutions, 10 commercial chambers representing the leading trade parties of Bulgaria which had invested over 20 billion euros in the country, had urged the authorities to reform the courts. A deep concern was shown over the long-awaited reforms of the judiciary and the impression that there was a lack of the applicability of the rule of law in the country, which had created a dent in the confidence among some of the investors. This had led to the withdrawal of the investors from the country. The consensus was that attracting investors and to get them to continue with their investments would become impossible without an independent judiciary. In order to support investments and to encourage the country's economic growth, there should be justice for business. To ensure that there is justice in business, the courts and the justice system has a significant role to play. The judiciary of a country occupies an important position in every civilized society. For a citizen, in order to lead a peaceful life, it is necessary that there is impartial and independent administration of justice. For the purpose of having economic and social development in a country, there should be social and political stability, and for that purpose, it is necessary to have proper law and order. Law and order would prevail only in a just society where human rights, human dignity, and human aspirations are valued. Such a society could be created only if the human aspirations and values are appreciated, respected, and safeguarded through an efficient system of administration of justice. For a normal human being, the judiciary is the only guardian and the protector against bureaucracy and tyranny. It is the only place they could expect vindication and challenge decisions of the state on even grounds. In a sense, for the citizen, the judiciary is the great equalizer. It is therefore apparent that in order to develop a country with economic viability and high potential for business and investments, it is essential to have a well-organized system of courts for the administration of justice. It brings to my mind the letter written by George Washington, the first US president in 1789, to Edmund Randolph, a former US Secretary of State, stating that the administration of justice is the foremost pillar of government. In such an environment, the next question that arises is as to what needs for proper administration of justice. In addressing this issue, it could be said that there are certain key features a judicial system should possess in order to create an environment for investors to bring in investments with confidence that it would be financially beneficial for them. Among these, the foremost is that a country should possess an independent judiciary. An independent judiciary is an essential feature for a functional democracy where the courts are treated as temples of justice. Referring to the question of judicial independence, Lord Bingham of Cornhill, the Lord Chief Justice of England, had said that any mention of judicial independence must eventually prompt the question, independent of what? And the most obvious answer was, of course, given: independent of government. The value and the importance of judicial independence for any society is immeasurable. If there is no independence in the judiciary, the general assumption would be that the scales of justice would tilt in favor of the stronger party that is before court. In such a situation, there is little or no value in having statutory safeguards, such as the takings clause in the US Constitution, if the court is not blind to the personalities before it. On the other hand, an independent judiciary would provide a firm assurance that courts would not favor politically or otherwise influential parties before them. Secondly, it is necessary for the judiciary of a country to have the confidence of the people, including the investors, as the strength of the judiciary is based on public confidence. Without such confidence, the courts would lose its authority and its ability to perform its functions. Confidence is something which is not easily achievable. Judges are also mere mortals, although they are being told to perform a function that is divine. However, it is essential for judges to take steps to cultivate, develop, and maintain the confidence of the general public in the administration of justice and the judicial system as a whole. Although there are many attributes in this regard, I wish to elaborate only on 3 major grounds. Firstly, it is essential that in the administration of justice in a country, there should be fair treatment and fair dispensation of judicial adjudication. Fair treatment or fairness in judicial adjudication, in my view, would act as a guarantee in many situations. It is fundamental to a just and reasonable decision that each party should have the opportunity of knowing the case clearly against them. It is equally important that both parties must be given an opportunity to present their version of the facts and make submissions on the basis of relevant rules of law. Neither party should be allowed to communicate with the judge without the knowledge of the other party. There should always be equal treatment for both parties, and otherwise there will not be fairness and fair play in judicial adjudication and administration. It would be the duty of judicial officers to hold the scales evenly and to be blind to the personalities before them. Secondly, it is absolutely necessary and is of fundamental importance that when exercising judicial authority, that justice should not only be done, but should manifestly and undoubtedly be seen to be done. What is important is that the court must be concerned not with a case of actual injustice, but with the appearance of injustice or possible injustice. If the maxim is correctly applied, there will not be any party who would leave the temple of justice with bitterness, anger, or hatred. Similarly, it is important and necessary to give reasons for decisions. The parties, especially the ones who have lost the case, have a right to know as to why they have lost it. Except in a system of palm tree justice, a party is entitled to know why a particular decision was reached. If not, not only that he would not be aware of the reasons, but also would lose the opportunity to challenge the decision in a higher court. The reasons for a decision not being available would lead to a lack of confidence or loss of confidence in a judicial system. Thirdly, there is an important reason which had contributed heavily to the loss of confidence in the judicial system. Persistent, permanent, and widely prevalent delays that exist in the judiciary, no doubt, is one of the foremost reasons that has resulted in the erosion of public confidence and, in turn, the confidence of the investors in a country. The delays could create several complications. With the passing of time, the memory is lost, deterrence is reduced, witnesses move or disappear, and costs increase. There would be emotional hardships, at least on some litigants. It would tend to undermine the efficacy of the whole legal system in a country. The culmination of all these would be to destroy not only justice, but also the development and growth of the economy of that nation. However, it is to be borne in mind that although expedition and speed are also necessary in the disposal of cases, this should not be the sole object of the exercise. The purpose of a fair judicial system should neither be the speed nor the delay, but to dispense justice within a reasonable time frame. Justice delayed, no doubt, is justice denied, but justice hurried could be justice buried. Just courts which could have a proper balance of the two extremes through rational and appropriate administration could be the symbols of good civilization and the ultimate expression of it. Having said that, if I may now look towards the future briefly, in addition to having an independent judiciary for the purpose of sustainable growth in the economic development in a country, it is also necessary for the justice system to be effective, less costly, and responsive to the people, including businessmen. Such responsiveness should incorporate simple, uncomplicated methods of dispute resolution. For these purposes, it would be necessary to take steps to improve the courts, which are directly dealing with commercial matters. In order to ensure that the procedure is less burdensome, it would be necessary to facilitate online case filing and to expedite the process in resolving small claims and complaints that are not complex and therefore could be easily adjudicated. In addition to a well-organized structure of commercial arbitration, it would also be advantageous to have special mediation boards, specially dealing with commercial matters on small claims to avoid long hearings. Serious thought should be given to the upper limits of such claims so that the majority of the small claims could be settled within the mediation boards without transferring them to routine trials. Special courts have to be established to deal with commercial disputes with fast-track mechanism in order to avoid delays regarding cases which do not fall within the ambit of commercial mediation boards. In conclusion, it is not necessary to say that businesses need adjudication. It would be the responsibility of any nation which relies on investments, foreign or local, for a rapid growth of its economy to ensure that there would be justice for its business. In order to fulfill this requirement successfully, it is a necessary prerequisite that there should be independence in its judiciary that imparts justice without any delay and has gained the confidence of the public. Thank you.